Right. Can you hear me? Yes. Hi. My name is Gianfranco Popolo. I'm a founding partner of PG Legal. We've been doing yachts for the last 20 or more years, so I think we have a little bit of experience in the Italian market and international. I will not bother, talking by myself or the firm. I will start immediately just introducing the speakers today. I'll be the moderator, so I will have to do not much, just introducing the moderator, the other speakers, and give a little bit of outline of what we're going to talk about. We have obviously Michael Moore, Jessica Galea from Dingley, James Allen from Arrow Monaco, and Richard Lambert from Burgess. I think the discussion today is going to be quite interesting, although at 9 o'clock in the morning talking about KYC is not exactly something fun, but it's certainly interesting. Also because all of us are generally confronted with these issues of KYC, asking clients documents and proof of their existence or source of funds, all sorts of things, which at the end of the day puts us also in a very difficult position. Sometimes I wonder whether we are sort of private investigators or actually agents of some sort of FBI or something like that, because we are asking questions which normally these agencies should already know about the people we deal with. And by the way, as you know, in any transaction, lawyers obviously are fundamental. But when we're talking about money, and we're not talking about cash, obviously, we're talking about banks being involved, financial institutions. So sometimes I wonder why there's a duplication or triplication or of all these people who have to control where the money is coming from and ask very difficult questions to our clients. As you probably know, just by way of introduction, at European Union level, in June 2024, there was actually a new AML package, which includes essentially two regulations and one directive. I'm talking about the 6th AML regulation, the directive, the AML regulation, which is an additional piece of legislation also, and the AMLA regulation 2024-1620, which basically provides for the establishment of a European agency, which includes, all the European central banks and central banks to have one central point of control on the AML and CFT regimes. What is actually the main objectives of the AML package? First of all, is actually to reform European Union's AML and CFT regime, then trying to standardize AML and CFT obligations and measures in the European Union, strengthen the supervisory system, and extend due diligence and reporting requirements to new categories of obligated entities, including traders of luxury goods. And that's why we're talking about this in the yachting industry. In particular, I would just like to make reference to recital 20 of the regulation 1620 of 2024, in which basically it says the motor vehicles, watercraft, and aircraft in the higher market segments are vulnerable to risks of misuse for money laundering and terrorist financing, given their high value and transportability. Therefore, persons trading such goods should be subject to AML and CFT requirements. Essentially, all of us involved in the yachting industry are, in one way or the other, involved. It will be the brokers. There are already the brokers. Certainly the lawyers, certainly the accountants providing VAT advice and so on. Anybody, and even now shipyards. This piece of legislation will be coming to force on July 10, 2027. So we still have some time, about 2 years, to implement the obligations of such directives and regulations, but there is not so much time. One other thing which I also like to point out, and then I pass the floor to my fellow colleagues, is that as far as we are concerned, there are some thresholds. And this also regards the brokers and regards also the shipyards. And the thresholds are of transactions which are above 7 million euros worth of, if you want, of the value of the yachts. So in essence, there is a lot of things to do. in order to implement the regulation and the directives. And obviously, you need to have some good consultants in order to advise on what needs to be done. Now, this is essentially the background, legal background. I'd like to ask Michael, I mean, what is your experience with KYC and CFT? I mean, like some real life examples.
Well, so I want to just, if you'll forgive me, I'd like to, we've all experienced KYC routinely in our deals, but I think the way it's normally handled is people just kind of roll with the flow. There's emails back and forth. Somehow it gets done, you move on, no big deal. It's a frustration, it's an irritation. But recently I had an opportunity to do 17 MYBA contracts with 17 different owners, 17 different yacht.
Can I ask where from?
I would defer on that, I suppose. A small kingdom, shall we say.
Okay.
So, as all of you have experienced, you get, no time. It's their lateness is we need to get this done in 10 days. We get our dancing shoes on and we start moving. Now, the lawyer that worked with me on this is a young man named Gabriel Pla, wonderful lawyer. He's now preparing for trial. And by the way, the trial is a credit to the yachting world. It's the case where the Fed ship, Utopia 4, hit the tanker, Tropic Breeze, and sank the tanker. So the Fed ship's fine, but the Tropic Breeze is gone. I'm just saying. It may be credit to the wonderful, legendary constructive techniques of the Fed ship yard. But I think the point I'd like to make is that for the first time ever, I could see in this sort of snapshot these 17, at some point, the 17 different yachts, the 17 different yacht managers, and the 17 different charter brokers in some cases, or if not the charters themselves. And KYC became the problem that prevented a number of our friends, the brokers, from making money. Now, I'd like to just say this, if I may, because it's what I've reflected on as I've watched one or two brokerage houses just cranking through these MYBA contracts, and then other brokerage houses having a lot more difficulty getting the KYC piece done. So I started thinking, in the yacht world, you usually have two lines. On the sales side, you have the listing broker. You have the owner, of course, the seller. You have the listing broker, you have the selling broker, and you have the buyer. And on the chartering side, you have the owner, the yacht manager, selling broker, and the charterer, right? So what is this all about? So what Gianfranco was talking about is that it's actually not about the people involved. It's the financial institutions that are under the gun to detect suspicious activity or other things that might reveal, we assume that it's at least some point in time actually has revealed a bad actor. But the laws are all over the place in the sense that there's only two laws in the United States, and that's the anti-money laundering law and the Patriot Act. But at the end of the day, when the stakeholder on either one of those lines, on the charter side or the sales side, holds that money as a stakeholder goes into the system. So right away, you're in the crosshairs. The English have their law, the the EU has its law, India has its law, the UK, and I think I just mentioned that has its own laws. So there's a lot of different laws. Malta has its own guidelines. Jessica will talk about that. But the real fun becomes when, particularly in the chartering side, when money is paid in advance under the APA. Now you're really triggering a red alert. And so the bean counters, let's call them, or the managers inside the brokerage houses, know they're going to get yelled at if they don't provide proper KYC. But it's really the banks, it's really the financial institutions. So when that big piece of change goes into the pockets of the yacht manager to be placed with the yacht owner on a charter situation, it's red alert as far as the financial institutions are concerned. So what brought this to mind, and the reason I think Paul and I were talking about this thing that I've experienced as I watched some brokerage houses printing money under apparently one set of rules, where other brokerage houses were frustrated not being able to get it done under a different set of rules. But at the end of the day, we didn't care. As long as the boat was situated in the Eastern Mediterranean, the Eastern Mediterranean, and can make it down through the Suez. So you could be in Monaco or Turkey or Malta. You would be cool as long as we had something in place on that day, or we were screwed. So we got it done. It was a beautiful thing, but it always got done by the charter manager, yacht managers who got their KYC done on time. Anyway, that's
yeah, it's exactly the point. I mean, one question I'd like to ask is also about, I don't know the way it works here in the States, but we know, for instance, in Europe, and also that's the experience also with the brokers, I mean, when is actually the time when you start asking for documents? I mean, Jessica, when is actually appropriate to start asking for documents? When have you already signed an LOI? Before then, you know, what is actually happens in Malta specifically?
So on the Malta side, as you all know, Malta is a prime yachting jurisdiction, not only for its flag, but also a buyer of a yacht, say, would consider to incorporate a Maltese company, Malta being a reputable jurisdiction, to buy a yacht. So even when somebody approaches us and says, we're excited, we're looking at this yacht, we'd like to set up a company to eventually be the buyer on this transaction, I say, okay, look, I'm going to be honest with you, Malta is a fantastic jurisdiction, yes, but I'd like to be clear from now, unless we clear the due diligence, we are not going to move anywhere. So let's start with that. Once we get the due diligence out of the way, you'll be organized and we can go to the transaction. But I'd rather clear due diligence from day one and be entirely honest with our client so that they'll be prepared for other entities, not only us as the corporate service provider or their advisor, but also eventually when the financial institution in the transaction will be also asking for KYC and source of funds. And then if that buyer is not even aware of what due diligence is and hasn't provided anything on day one, then there could be some hiccups at the time of completion of the transaction. So I'd like to be honest from day one. And one time a client understood that I was asking for due elegance. And I said, no, there's nothing elegant about this here. This is something that has to be done. Due diligence is compulsory. And I also like to tell them that it is not a one-time exercise, it's ongoing. So if you are going to be staying with me as your advisor and you're going to have a relationship with our firm, you are going to require to give us ongoing updated due diligence because we are an EU member, and as a corporate service provider, we are regulated and we have a set of guidelines with a minimum amount of due diligence requirements which we need from all our clients, and those need to be renewed every 2 to 5 years. So I always like to tell the client also that this is not only a one-time exercise. Be prepared to receive these questions throughout our relationship. But once I clear that and it's understood, I also am comfortable knowing that my client has nothing to hide and I don't see any hiccups then during the actual transaction. Another thing I like to promote is transparency. So where as much as possible, if you're buying a yacht under the Malta flag, if you're an EU national, EEA, Swiss or UK, you can own a boat in your own name. But for liability issues, people tend to prefer to go for a company. Now, that corporate structure should ideally be as transparent as possible. The more layers you have will mean more checks, more magnifying glasses from the institutions, who at the end of the day have every right to carry out an inspection any day. So you could be halfway through a transaction, think everything is smooth, get a call from our financial intelligence unit saying, Jessica, we need that file. We're coming to inspect your client's records at your office tomorrow. And if I'm not prepared, I'm in trouble and the client is too. So it's a dual liability, and it's all about who's responsible and the nature of the transaction as well. So from the Malta side, I think we take it very seriously, and I think it benefits all the parties in the transaction.
Richard, I mean, tell me something. I mean, especially for brokers, I guess, you know, it's quite, I wouldn't say embarrassing, because now it's actually what happens. It's been like this for some years. But I guess when you have a client who's really adamant in buying a yacht, they want to sign an LOI as soon as possible, they want to pay the deposit and so on. When is it actually the time when you start asking for all the paperwork?
I think, I mean, now, as you said, I mean, going back a number of years, then you used to get a lot of pushback from clients, but I think most people now are pretty accustomed and to having to provide this information, so having a suite of documents available fairly quickly. Us as an organisation, it's very early on, and okay, you are having an initial conversation, maybe a new client, but you've got to start to turn around and speak to that client and condition them the fact that we will be after quite a lot of due diligence from them very, very early on. Before we sign any central agency agreement, we have to have the KYC in place. But naturally, exactly as Jessica was saying, this is an ongoing situation. It's not a one-off. It's a case of, right, we know who owns the yacht. We know who's behind it. We've got the right documentation in place. I mean, I'd love to say that we sell all of our CAs within the period of times before the KYC expires, but it's not actually the case. So it is that ongoing relationship. But it's always, I say, bring it in as soon as possible to manage those expectations. I mean, we're a monogas company as the SAM. We've got the AMSF, which is in Monaco, ex-SICFIN. We're very, very heavily sort of guarded and regulated through Monaco. So for us, we have to give regular, I mean, to the teams as well. So all of our teams throughout the business, we have to give regular KYC training. Everyone has to sign off on the fact that they've undertaken that training.
There have been some cases in Monaco whereby some brokers have been actually, I wouldn't say sanctioned, but suspended for sure, because there have been some cases where clients were not particularly well checked, if you want.
So, I mean, it is a process. I mean, we've got a whole team, a whole compliance team in place internally to be able to handle it, especially as we're saying with the charters as well, and the volume of charters that we're doing. There's a huge amount of work that has to go in before we can even get it over the line. So, yes, I mean, it's become a very integral part of our daily life. But my advice to anybody is do it early. Get in there early, and because actually you don't want to get so far down the line and realize you've got a problem.
Yeah, exactly. I mean, that's really the most important piece of advice to keep, because in any single, whether we're talking about the purchase and sale, or also in case of a construction of a yacht, it's better to have everything already like in place at the outset. And James, tell me also, as a yacht manager, do you also have this sort of situations whereby you're signing for a new client and then you're managing, or actually you're managing the construction of a yacht? Are you also in a way subject to this type of regulations? Do you ask for all these documents and so on?
Yeah, I mean, very similar. Being in Monaco, we're hugely regulated, especially at the moment. I think we all know Monaco's on the grey list, trying to get themselves off it. So in terms of inspections for companies operating in Monaco, it's very, very strict. So exactly as everybody's saying, KYC is really, really important. We have our own specialist department dealing with it. Some of our relationships are obviously quite long when we're building yachts or managing yachts, and the KYC constantly has to be updated. So, and we also find, in terms of the nationality of the clients, some clients are used to it, particularly in Europe. They often have a file ready to share. American clients are less familiar. So we've had several clients get very upset because we're basically asking them for some very personal information, which they're not so keen to share with us sometimes, especially very early on in a relationship.
Yeah, I think that's the key, just what Jessica was saying as well. The more complicated the structure, and especially if you've got trusts in place, and you're then having to dig down into the detail of the trusts, as you're saying, it's a very, very sensitive area for a lot of clients that they don't necessarily want to divulge.
Well, actually, what I find also particularly difficult is to ask the clients about source of funds, you know. I mean, obviously, the client is a business person most of the times, or a professional, whoever, I mean, whatever, you know. But when you come down to source of funds, and sometimes you're even required to ask for bank accounts. I mean, Michael, how is it here in the States? Do you have the same sort of obligations which we have in Europe, asking for all sorts of really personal sort of details?
Well, it actually just got worse. And basically, I would urge everyone, as you're hearing, you understand that everything that's being said in terms of compliance is basically how do you keep the bank happy. Whatever bank where Burgess puts its stakeholder monies or puts its APAs or its charter revenues or its purchase and sale proceeds, however that's structured, it's the bank that throws them under the bus later, and they get yelled at because it's the banks historically, and I'm going to address your question because another shoe just dropped recently. It's all about guessing what will make the bank happy. So it's not so easy. Certainly, Arrow and Burgess, and they really were the toughest ones in Monaco. The Monegasque authorities were bears. I mean, I assume because the brokers obviously wanted to do the deal, the managers wanted to do the deal, but it seemed like nothing was ever enough. You feel bad for the people that are trying to make a living, trying to close a deal, and so you get someone who's based in another country, I won't name one because it'll be unfair, when they're just scrolling through, 3 pieces of, one passport and a utility bill and a picture. It's like, okay, that's it? No, that's it. Well, but here's the problem that you referred to, Richard. The United States has now tried to pass, and it's an interesting thing when you're dealing with the Donald Trump administration and the Supreme Court and all the federal courts. It's called the Corporate Transparency Act. And it literally has been bouncing between federal courts here and there, particularly one in Texas, up to the Supreme Court and back. And if you read this thing, it's all about beneficial ownership. They could care less about trust, structures, all the things that lawyers kind of love to yap about, like we're doing. And they go, no. We got to see the human being in there. And I don't know about Rob Moss, if your firm, I got a Corporate Transparency Act disclosure form. And it's crazy because it goes on forever, first of all. And it's all about who is the beneficial owner.
That's for sure. That's exactly the whole purpose of the legislation. I mean, now I don't know if actually started first in the US and then in Europe or vice versa. I don't know, but certainly the whole thing is about really coming to the ultimate beneficial owner.
But it's no longer about. Before it was the Patriot Act and money. Where's the dirty money coming from?
Follow the money.
And the Money Laundering Act about money. And by focusing on the money, you thought and if the banks were careful to make sure the money was clean, which may put the burden on the lawyers to do the work to make the bank happy. Now, Corporate Transparency Act is they asked a bunch of questions. Do you have any foreign investors? Do you have any foreign shareholders? Do you have anyone? And they ask you what is your nationality? What is your tribal affiliation? And what is your, and they try to capture you no matter how you try to wiggle it. Of course, we're just trying to make them happy, but it's a major form. I actually have a form if anyone would like to see it. It goes on for like 5 pages. But it's the new nightmare for lawyers. We've actually started sending these things out to our clients and saying, if you want us to handle this for you, we'll do it. But by the time we handle it, the law's changed. It's now bounced back from the Supreme Court. Now it's back in the federal court. Now it's go back to the Supreme Court.
And I suppose this type of form also implies that you are personally liable in the case you don't provide.
Totally. It's a big exposure. And if you don't appreciate that, I would just simply say, if you think the government doesn't, know what you're doing, we got on a deal that sent a yacht to Cuba. We got a personal letter, we should have framed it, from Michael Pompeo, the Secretary of State, saying, don't do that again. And it was like, and if you do, you're going to prison. So we thought, okay, we're done. But it was like, you know, do we frame this? It's not every day we get this wonderful, obviously electronically signed letter, but still it had his name at the top and the seal of the Secretary of State. A very scary letter for a yacht owner when they're not yelling at the yacht owner, they're yelling at the law firm. So I think it's a moving target. That's kind of what I'm trying to get across. Sure. And usually, and it seems to be getting worse, except last week on the Amadea case, I'm sure many of you followed, you know, the government decided, even after Trump decided we're not going to prosecute any more Russian surnamed people, the federal court in New York still ruled that the boat belonged to the United States of America, and that the Russian was a straw person. So a little bit of the same sort of problem.
We have everywhere, also
yeah,
in Italy.
And I'm sure you're confronting it as well.
Jessica, for instance, I mean, as you know, I mean, being, I mean, the Maltese and Italian legislation based on European directives, I mean, do you also have the obligation to report to your local authority if you have the feeling, actually, you have also information regarding a transaction which is going to be carried out by somebody who's got some problems in terms of KYC? And are you also obliged by your own legislation not to inform, obviously, the client that you're going to report him?
Precisely, yes, that's the position. Our system is a risk-based system, so the minute the risk factor is high, we are obliged to report that transaction to the authorities, even if we have such a good relationship and suddenly something is suspicious. It's our obligation, because ultimately we are also responsible, and that is it. It's our duty, and these things happen, unfortunately. Sometimes once we've reported it, we just don't hear anything further. Now it's up to the authority to look into that transaction. But I also wanted to say that throughout these discussions we have had here today, there's constant requests coming from different entities. And one thing that Michael and I discussed yesterday was how none of us can rely on each other, because that's a huge responsibility. So we don't depend. So let's say if I am working on a matter and then somebody comes into the picture and says, oh no, Jessica, just send me your due diligence file and I'll rely on that. We can't accept, and our law prohibits it. So each entity involved in the transaction would be responsible to carry out their own KYC. You cannot rely on anyone else. And that's why it's great where there's a specific guideline where there are minimum requirements for due diligence, so everyone could be asking for more or less the same basic due diligence. And then when it comes to a financial institution like a bank, their due diligence requirements are essentially stricter. So at least having a basis is helpful, because like that you all ask the same thing. Even in this case that Michael had with those 17 yachts, it would be ideal if something like IYBA and MYBA could get together, even though their members are in different jurisdictions, having a minimum guidance as to what requirements you should ask for when it comes to charters like these would be really useful, and prevent something like this happening again, where Michael would have had his set, which he could share with the 17 brokerage houses, and then if any of them wanted anything more, they would have asked for it. But at least having the same set would have made it much easier for somebody like Michael, who was representing the charter, I believe.
Yeah. And you, I mean, have you ever actually had some real case scenario whereby you have not completed a transaction because you also had the suspicion that, you know, the people involved were not completely clean?
Yeah, absolutely. I mean, but as I said, I mean, that's why...
In Monaco especially, it's like
I mean,
very strict.
Yeah, very strict. And absolutely, we've had a number of, transactions or client interactions. And I said, do that KYC early, because you can very quickly turn around and say, I'm terribly sorry, we can't go any further. I'm not prepared to go to jail for anybody for any yacht transaction or any charter. So it's an absolute no. So, but interesting what you were saying with my MYBA hat on, with the new EMOA and also with the new charter agreement, we've actually turned around and built KYC into both of those agreements. And we did put together also a sort of a KYC list there. But the issue we've got is the fact that, exactly you alluded to, it's so difficult in the different countries and jurisdictions on what is required. And I think that's one of the big, exactly, we talk about Monaco being particularly difficult and we're under a lot of scrutiny. As Michael was saying, here in the US, it's still a lot easier to turn around and transact. And I remember a couple of years ago at the Superyacht Investor Conference, Robert Allen was turning around and saying, don't worry about KYC, come to America, it's all fine. And you think,
He missed that.
I listen to you, but
Want to repeat that, please?
So, and I think that's one of the problems, is the fact that actually, I agree with you, if we could standardize it across the industry for sales and charter, it would make life a lot easier. And with MYBA, we have tried to turn around and put in something
I
there
would
that's
like
a
to.
guide.
I'd
This is actually what's happening,
Yeah.
because especially in the luxury asset sector, now the various representatives of the various associations, especially in Italy also, they're trying to harmonize, if you want, the requirements across the various industries. Then, obviously, ideally, it would be good if this could also happen at a European level, but I find it difficult to believe that this is going to happen. But brokers, yacht managers, lawyers, as corporate service providers, obviously we are very central to the entire industry. I think it is important also to exercise some sort of lobbying to convince the authorities that obviously we will put together all these pieces of paper, but in reality we need to see something which does not stop our business. I don't know, James, I've seen, for instance, with insurance companies, banks, now I guess they're more involved into compliance than actually performing their own activities. Does this also cause you some problems or not?
Yeah, definitely.
Yet?
On the practical front, banks, insurance companies, anybody that we work with, employment companies, they all need to do their KYC. And if we can't open an operating bank account for a boat, we can't run a boat. And sometimes we have to choose the bank that we work with based on what we think is most likely to work for a particular client. And sometimes we get to a point where we physically can't open a bank account in Monaco, in which case we have to go back to a client and say, well, can you provide the bank account? Sometimes they will, sometimes they won't. But there's been times when we haven't been able to work with people, not because there's any issue with that person, there's nothing wrong there, we just can't physically get bank accounts and the infrastructure set up, maybe because of media reports about that client and things like that, and maybe not found it. But it's enough to make these institutions nervous.
For yacht managers, for instance, you receive money constantly in order to operate the boat, then all of a sudden the owner of the yacht comes on a sanction list or has some other problems, and therefore you cannot even receive the money which is needed for the operations of the yacht. So it's a serious problem.
That's a very good point. Because in the three main registries, people are identifiable as on the list or not. But of course, the person who just got denied their rights in New York last week, they were just simply, the court just said, well, you're not real. The real person is on the sanctions list. And so you're out, and now the United States has this large yacht to deal with. I want to say this, I think the other point, and I think Richard made this point, is such a beautiful world that we live in, because a lot of things, and thanks to Ed Ryan down in the Cayman Islands, we have created this master kind of list. But there are people, there are actually humans sometimes behind all of these initiatives. And so we had a situation, I won't go into specifics, but it's exactly what James is talking about. We had a client who had never seen a utility bill and didn't know what a passport is, and probably, he probably would not allow himself to be photographed for a variety of security reasons. And so we were able to go to the authorities. It's usually a banking system. In this case, it was the Cayman Islands. And we were able to say, look, we need to have a conversation, and then we're going to tell you, why you're never going to get what you're asking for. And they worked it out. It was like, okay, no problem. We got it done. Go, have a nice day. It was like, okay, that was great. But the reality is that in the yacht world, among almost all other worlds, you have these people that simply don't nicely fit into, and they leave it vague. See, intentionally, you were talking about a list. They don't want a list. They want it to be vague, intentionally vague, because if you draw a list, every lawyer in the room will figure out a way to go right up to that list, and that's it. In the old days, if you had $10,000, remember those days? $10,000 of cash was a suspicious activity. So all the deposits were $9,999. Yeah, that's right, because some clever lawyer probably sitting in this very room, told his client, well, you know, if you just do $9,999, you'll be fine.
I don't know who's the lawyer is, but I don't think it was very clever because, as you know, the limit certainly is 10,000 euros. Now, also with new legislation, it will be 10,000 euros across Europe. The problem is it's not 10,000 euros in one transaction. I mean, you can be a series of transactions. You have to consider the total amount.
Suspicious activity.
Exactly. I mean, if you repeatedly pay $1,000 and then you get to 10,000, then I mean you're still violating the spirit of legislation. That's the problem. Yeah, I mean, certainly, I mean, there are a lot of issues which arise. What is something really typical for brokers you face, I mean, every time when you're dealing with clients? Like, for instance, are you asking for the source of business? Do you also ask for a bank account abstract? Like, no.
Source of wealth, for sure. I mean, we're after, and there are a lot of times, and as I mentioned with the trust, I mean, if you're selling a boat and say that yacht is owned in a family trust, and you suddenly have to dig down into all the details of that trust, that gets very, very sensitive, and people get very, very resistant, I think, to providing that info. But I think, I mean, for us, one of the difficulties now is, and you touched on it, as acting as stakeholder. For us to act as a stakeholder in a sales transaction in charter, it still operates. And I completely understand what James was saying about the difficulty in operating accounts as well throughout Monaco. These are real challenges that we face on a day-to-day basis. And I think, I mean, if you think about the amount of hours that all of our teams are now collectively tied up, man hours tied up with dealing with KYC issues, I mean, it costs us a fortune in absolute reality. But in a sales transaction, it's very, very difficult for us to act as stakeholders. We can do it, and we have done it, but the hoops that you have to jump through, you have to work with the bank, as you were saying, very, very early on. They're insisting on the full information from the whole transaction, the full KYC, before you can even send a single euro for that transaction. And that's where a lot of these challenges lie. And I know actually for holding funds, it's a simpler process for you as lawyers than it is for us.
Well, it's not really. I mean, Jessica, for instance, escrow agents, I mean, have you worked as an escrow agent sometimes in transaction in Malta? And is it something which, is it still possible to do without getting involved with all sorts of problematics?
It can be problematic. It's not one thing I promote, but if there's need for us to act as escrow agent, the first thing I'd say is we need to extend the closing date by 3-4 weeks, because I would never know what the bank is going to look into. And sometimes my worst nightmare is where the day before closing, I get a call from the bank saying, okay, can you just explain further on the source of wealth of the buyer? And I freak out because I can't accept that they leave it so late. But the reality is that today financial institutions are loaded with KYC. We all are as service providers as well. And I think that when they actually get to your file, even if you've filed everything with them 2 weeks before, it's a matter of then the party consent to really take an interest, follow up, if you really want to give that service. And if I want to act as escrow agent, I'm going to make sure that I clear everything with the bank before I can say, yes, we can act as escrow agent. So in the same way, when I'm incorporating a company, as escrow agents, it's actually stricter because the money is going to be passing through our account, held there on trust until the closing is complete and we can transfer to the seller. But our bank, as a receiving bank, puts us really on our toes, and I really find that it's not one thing I promote daily. It is only where it is a real necessity that, and I'm much happier to do this where the structure is really straightforward and there aren't many layers until they reach beneficial ownership.
Yeah, Michael, yeah, I think actually, I mean, as I was saying in the very beginning, I mean, putting us on the spot, like lawyers, again, accountants and so on, just to duplicate the number of information, the number of questions, and keeping files all over the place, it gives me the idea that really the authorities want us to be liable if we don't find something. But I wonder, I mean, if you have agencies like FBI, for instance, or CIA, or the equivalent in Italy, or the Bank of Italy, or the Central Bank of Europe, or whatever, why do we have to be involved and potentially liable?
I think it's a very good question. We're always agents, so we have principles, and we don't have knowledge of our principles to the depth that they require us to have. It's like we have some sort of magic password. We actually had this recently, which I was shocked that the client agreed to give us a password to this vault. And it's like, wow, that's kind of a heavy responsibility, because now we had access to something that I wasn't very happy about having access to. But I think some of the things, there is a little levity in this, because as source of wealth, daddy is not a good answer. And oil is not, not a very specific answer. So you have to be, sometimes, talk to the clients. Yeah, I don't know how we became the policeman for the world, because it really is a global problem, and we can almost always, Richard and James are victimized, not in the sense of, they're in a great, wonderful place, but it's also a very tough place in many ways for KYC, and it was the very specific example that I was talking about. It was driven by the banks in Monaco, who were so worried that they're busting our chops. Now, see, they don't really make any money, the banks don't. It's just another day in the office. Yeah. But the broker needs to close the deal. So absolutely. I don't know if that answers your question, but I don't know how we became the policeman for the world, but it seems like that's our role.
One last point, and then we'll ask questions if anybody wants to ask questions about these KYC issues. Crypto, and transactions, I think is really the issue in terms of, KYC. Have you ever encountered, or have you been involved, James or Richard, into any transaction which got to do with crypto payments? And what do you do when somebody's going to propose something like that in terms of KYC and?
It's a really interesting one, and I think there's been a lot of talk about crypto. There have been transactions where I know that crypto has been involved, but it's a case of when we've been involved, it's a case of we're not actually interested in the crypto. You've got to turn around and convert that into whatever currency we're talking about, and we go through exactly the same KYC and AML requirements. So we've not done a transaction which is where somebody's accepted crypto, for example. It's been, I know in the background it's turned around and been converted from crypto into regular currency.
Yeah, I'm saying because I know that some brokers actually have been involved recently in some transaction with crypto. Now, as you said, I don't know if it wasn't necessarily a conversion of the crypto into the actual currency, or it was just crypto, but just by itself, just the word crypto obviously, makes a lot of sounds and bells, and putting on alert the whole thing.
It's something that recently has gained, almost overnight it seems. So one of the firm's clients was on the cover of Forbes and Crypto King. He's a yacht guy. He has 9 boats. Kind of an unusual man in many ways, but 70% of his wealth is in crypto. Okay, and he's all in favor of something called the Crypto Strategic Reserve, which at some point I'll figure out what that is. But apparently Donald Trump, that guy again, thinks it's a great idea. And so it is a little bit odd. No one that I've ever talked to have been able to dumb it down enough for me to understand what it really is. But we haven't done any transactions in crypto. I don't think we have the capability of doing that. But I think it's something that's just barreling toward us. Is what it comes down to. What I think is happening. Because he was actually this gentleman. This is a strange thing, but we've all have these odd clients in this industry. So he called a party at his house on the 20th of February, and a very select group of people were invited, and he didn't show up. He which is kind of unusual but then he moved to Washington. He went to Washington. They said, well, he was called to Washington. So it's got to be about crypto. So I think there'll be announcements very soon about what that means for all of us. But for our practice, it hasn't been a thing, except this one guy has a big holding in that type of currency, but we've never been asked to do a transaction in crypto.
Okay, I know that we're actually almost over with our time. If you have any questions regarding what we discussed until now, please. Giorgio, you want to say something? Because I know you have some experience and you have some very deep knowledge about, AML, especially when it's got to do with shipyards. Are you, as Benetti, in-house counsel, preparing yourself also to the implementation of new legislation?
Yes, we are, and we are having a lot of troubles, in particular with banks in this period, because, as I was saying to Rob, now banks implemented an internal policy which is quite similar to all banks which are in the, which have a branch in the US, saying that they not accept payments coming to people who is born in Russia. So an original sin. So how can I say to a client, no, I can't accept your money because you can't pay because you were born in Russia, even if you are not sanctioned at all. And so this is very difficult. We found out only a couple of banks which are not in the SWIFT program, and that are accepting money coming from people who, the one who clicks the button has not to be born in Russia, and that is really difficult.
But is something which has got to do with the US, or because I mean in Europe, I mean I never heard anything like that.
They fear. What I think is that they fear secondary sanction rules in the US because they have branch in the US. They in the past has been fined.
Okay.
For a very big amounts. I'm
like
talking about
like BNP Paribas.
BNP Paribas, Unicredit, and Intesa San Paolo, the three. And so they are so scared that they put on a wall. So this is very difficult. And also for people who is resident in Russia is very difficult.
I mean, residents in Russia, yes, in terms of sanction, I understand that, but obviously being born in Russia, I don't see, at least, I mean, the
But
reason.
you've still got, I mean, if you look at the regulations that are all tied to in yachting, with anybody with any form of Russian nexus, it's still exceptional. I mean, we can't transact. I mean, especially if they are resident in Russia. I mean, it's
If
just
they are
resident, no, sure.
If they on my point of view, I can't sell boats in Russia, but I can sell boats to Russian people who is not sanctioned, and with the performance of the sale in Italy or outside Russia. And we need to put on protection on the contracts, saying that as far as possible, the clients is bound not to use the yacht in Russia. This is something quite complicated to achieve, because if they sell it back, we can't say. But we have to demonstrate we are doing whatever we can to avoid this. And this is difficult. We have to work a lot on KYC, and it comes out, we start KYC procedure when the negotiations start. And it's difficult for us to say to our salespeople who come to us, no, you can't sell this boat to these people, or to companies that ultimately are connected to someone, because we have to check the empty box or the structure, the trust they construct, till to arrive to the people who is the shareholder, the director, and to check them on databases. So it's...
Well, I guess probably now it's a conclusive note, if you want. One solution to all these problems may be coming from the technology once more, like, from blockchain, because that's actually the hope also of the European regulation and directive, is actually that everything is going to be on the blockchain. All the documents will be essentially not even passed anymore, like in terms of physical documentation, but rather through the blockchain. And with this, I'd like to thank you for listening to us. I guess our time is over, and I'll pass the mic to Paul.
Thank you, Gianfranco. Thank you, Richard, Jessica, Michael Moore, and James. Thank you guys very much for actually an interesting KYC. We all think KYC and roll our eyes, but you guys make it funny. So thank you very much for joining us this morning.
Sometimes you have to laugh, or are you crying? And that's the only.
You're either laughing or crying. Welcome to Lawyers. For those of you in the back, there's some seating up here in the front that's available. I mean, I know lawyers usually sit in the front. The reason we're yacht brokers is because we sat in the back. But please come on up to the front. There's plenty of room up here.